Hi, I'm Greg Corombos. My guest at this time is Andrew C. McCarthy, former Chief Assistant U.S. Attorney for the Southern District of New York. He's now a contributing editor and columnist at National Review Online and is a Fox News contributor. Today, we want to get Andy's analysis on the Supreme Court's decision against the Trump administration's efforts to end the Deferred Action on Childhood Arrivals program, better known as DACA. DACA was instituted in 2012 by President Obama through an executive order. And Andy, thanks so much for being with us.
Greg, my pleasure.
Well, there's, of course, a debate to be had on whether the Trump administration should end DACA, but the question before the court is whether he can, or was the question before the court. Conventional wisdom suggests anything one president can do simply by the stroke of a pen ought to be able to be undone by another president, also by the stroke of a pen. But John Roberts and the four liberal justices concluded on Thursday that the Trump administration failed to give a good enough explanation for doing this as required by law. So which side has the stronger constitutional ground here?
Well, it's really, in that sense, Greg, it's really not a constitutional case. I mean, they've decided the case under the Administrative Procedures Act. As a matter of strict constitutional law, a president can undo anything another president has done by executive order. Because if you're dealing with something that truly is an executive order, and I highlight truly because the trick here is always to figure out, is the president doing something that is legitimately done by executive order, or is he legislating and trying to call it an executive order? But if you're truly doing a legitimate executive order, what that means is the president is simply exercising the plenary executive power that he has either under the Constitution or because Congress has given it to him in a statute, or he's ordering the executive branch in some way he's allowed to do, just like a general organizes the military and says you do this, you do that. That's the kind of stuff you can do by executive order, and that's completely legitimate. The problem I have with the DACA decision is that I don't think Trump is being held to the same standard that other presidents are, including the president who not only installed DACA, but said, numerous times before he did that he couldn't, that he didn't have the authority to do it. So here you have Obama does something that is really not an executive order because it was more in the nature of legislation. The president doesn't have the authority to confer immunity on categories of immigrants and to confer benefits on them. Only Congress can do that. So here's Obama doing something he himself conceded that he was not allowed to do, and usurping legislative authority. And along comes Trump saying, well, if that was done by executive order, I can reverse it by executive order. And that would bring us back to a status quo where the president isn't legislating. So you would think we would prefer that in our system. And instead what they say is, a bunch of mumbo jumbo about how he didn't jump through all the hoops of the Administrative Procedure Act. And I just, as a practical matter, I don't mean this so much as a lawyer, Greg, as I do as just a citizen and somebody observing all of this. If you're going to treat a president's executive order, like Obama's DACA order, as if it had the force of law, as if it was so resembling of legislation that there was a big procedure that the next president had to go through, almost like a congressional repeal in order to get it done, then what do we need Congress for? If we're now going to start letting these guys issue proclamations and then say the next guy can't reverse them because they have the force of law, then they're not executive orders anymore. And this system isn't the system that we designed anymore.
Yeah, it's a very different system if the executive can simply will things into existence and successors can't do anything about it. That is a very different system. I do want to get your thoughts on another issue from Roberts here, because in addition to suggesting that the administration did not give a good enough explanation for going down this path, he also says the administration failed to account for the impact ending DACA would have, for the hardship inflicted on the recipients, for example, if the program were to be rescinded. And while that obviously is a fair policy concern, anytime you want to change policy, you need to consider the impact that it's going to have. Is it a constitutional concern?
it's a statutory concern. Again, I think what Roberts is saying is that these are considerations that the Administrative Procedure Act requires before what we're thinking of as an executive order, but what they're thinking of as an administrative determination. Before you can alter one of those, you have to go through this calculus of, what is it that you're changing? What's your explanation for changing it? What's the fallout going to be from changing it? And that's all very well and good if you want to say this is good management practice for any chief executive. If you're going to make a big policy change, these are the things that you should think of. But if this is actually, if we're actually doing constitutional law where let's pretend the president actually runs the executive branch, then he's supposed to be able to reverse that. And Congress is not supposed to be able to prescribe what the president must do in order to reverse an executive determination by his predecessor. I think that's the objectionable part of it. We're calling it an executive order, but we're not treating it that way. So what we're essentially saying is what Obama did, because it was Obama who decreed it, that has the force of law, and no future president can just change that. You have to go through an elaborate process. And I think that would have been surprising to the Obama administration if somebody had said that they couldn't change the law that way.
So, Andy, this law, which I think a lot of folks weren't familiar with or perhaps hadn't even heard of until today, I'm certainly new to it, that you have to come up with this explanation. Does this come up a lot in federal cases, or is there some merit to the argument that they're grasping for straws here to basically punt this issue on the merits back to the Department of Homeland Security?
Well, it's a good question because it comes up a lot because we're swimming in administrative regulation. When people say that we're living in an administrative state, that is a pretty radical departure from the tripartite system that the framers gave us. They're not lying. I mean, that actually, we do have this framework now where layered over the system that the Constitution prescribes is this vast array of federal agencies, some of which are housed in the executive branch, some of which presume to be hybrids of sort of a combination of federal, judicial, and legislative authority, which is something the framers would have frowned on. And we're now to take it that is our governing system, notwithstanding that it's not the one the Constitution provides. And that if the pronouncements or the decrees we're dealing with are coming out of the administrative state, as opposed to coming out of just the presidency, then the president has to comply with the administrative rules in order to work any change on them. And I just think that's a very sharp departure from the system that the Constitution gives us. And it's something that's happened incrementally over time. But I don't think anybody ever voted for this.
Andy, it was just earlier this week following the Bostock decision on the Civil Rights Act that Senator Hawley reamed Congress essentially for punting its duties to the judicial branch to essentially solve things that lawmakers are too timid to vote on because they're controversial, and they'd rather just have the judges who don't have to face voters deal with it, and then they can remain popular. Justice Thomas, in his dissent today, basically accused the majority of being timid and refusing to make a decision on an issue that was controversial, but he said it was also obvious what the Constitution required in this case. So what do you make of what we're hearing in terms of folks not wanting to go on the record with what might be an unpopular ruling?
Yeah, well, I think there's a lot of force to what Justice Thomas said, because as you pointed out, Greg, when we began this conversation, the Supreme Court majority today didn't say that Trump can't get rid of DACA. So they didn't want to plant their feet and say, we're making a policy decision, even though it's clear that this block of judges wanted to preserve the policy. They basically said he just didn't do it the right way. And, we've seen this kind of thing again and again with with all the branches of government, but particularly with Congress and the courts. I remember with the Military Commissions Act, the Supreme Court jumped in when Bush tried to impose military commissions, and the court said, we really need Congress to sign off on that, even though historically that was not true. So then Congress turns around and passes a Military Commissions Act, and in the next case, the Supreme Court says, no, you didn't do it right. So I remember tartly, Justice Scalia, in his dissent, said, turns out they were kidding. And you get that a lot. We have a lot of hot potatoes that nobody wants to deal with. And it isn't fair that, the Congress passes ambiguous legislation and then dumps it in the court's lap to work it out while the people in Congress go on cable television and rail about it. But it's also not right for the Supreme Court when they have something that they should decide. Like this week, they've decided not to deal with the Second Amendment. They've decided not to deal with immunity for police in the kinds of situations that we've been seeing again and again. And that's a judge-made problem, but they don't want to deal with it. And Congress doesn't want to deal with it either because they might be unpopular if they deal with it. So there's a lot of this going on. And I guess the lesson we ought to take away from this, Greg, since we're talking about the administrative state, is the framers wanted a more streamlined government, not just because they wanted the federal government to do less, but also because they thought the most important thing in a government is accountability. And that when it gets too sprawling, everybody can point at everybody else and say, no, that's your job. And nobody ever gets held politically or any other way accountable for anything that goes wrong, to the point where we had, was it Rod Rosenstein a week or two ago, testifying in a Senate hearing where he somehow tried to explain that he was responsible for what happened, but he wasn't to blame. Yes, someone can figure that out for me, because it hurts my head when I try to do it.
Fascinating thing, but it's typical in Washington, and it's not beholden only to one party, I assure you. So, Andy, it's fascinating. It's maddening in some ways, but we'll be watching to see what the rest of these decisions look like the rest of June here. Thanks very much for your time.
Thanks, Greg. Enjoy the apocalypse.
Andrew C. McCarthy, former Chief Assistant U.S. Attorney for the Southern District of New York, now a contributing editor and columnist at National Review Online and a Fox News contributor. I'm Greg Corombos, reporting for Radio America.